I'm recording. So Justice Kennedy gave the opinion in 2002 to a case called U.S. versus Drayton in the stop and frisk section of criminal procedure. On February 4th of 1999, respondents Christopher Drayton and Clifton Brown Jr. were traveling on a Greyhound bus en route from Fort Lauderdale, Florida to Detroit, Michigan. The bus made a scheduled stop in Tallahassee, Florida. The passengers were required to disembark so the bus could be refueled and cleaned. As the passengers reboarded, the driver checked their tickets and then left to complete paperwork inside the terminal. As he left, the driver allowed 3 members of the Tallahassee Police Department to board the bus as part of a routine drug and weapons interdiction effort. The officers were dressed in plain clothes and carried concealed weapons and visible badges. Once on board, Officer Hoover knelt in the driver's seat and faced the rear of the bus. He could observe the passengers and ensure the safety of the other 2 officers without blocking the aisle or otherwise obstructing a bus exit. Officer Lang and Blackburn went to the rear of the bus. Blackburn remained stationed there, facing. Lang worked his way toward the front of the bus, speaking with individual passengers as he went. He asked the passengers about their travel plans and sought to match passengers with luggage in the overhead racks to avoid blocking the aisle. Lang stood next to or just behind each passenger with whom he spoke. According to Lang's testimony, passengers who declined to cooperate with him or who chose to exit the bus at any time would have been allowed to do so without argument. In Lang's experience, however, most people were willing to cooperate. Some passengers go so far as to commend the police for their efforts to ensure the safety of their travel. Lang could recall 5 or 6 instances in the previous year in which passengers had declined to have their luggage searched. It also was common for passengers to leave the bus for a cigarette or snack while the officers were on board. Lang sometimes informed passengers of their right to refuse to cooperate. On the day in question, however, he did not. Respondents were seated next to each other on the bus. Drayton was in the aisle seat, Brown in the seat next to the window. Lang approached respondents from the rear and leaned over Drayton's shoulder. He held up his badge long enough for respondents to identify him as a police officer. With his face 12 to 18 inches from Drayton's, Lang spoke in a voice just loud enough for respondents to hear. "I'm Investigator Lang with the Tallahassee Police Department. We're conducting bus interdiction, attempting to deter drugs and illegal weapons from being transported on the bus. Do you have any bags on the bus?" Both respondents pointed to a single green bag in the overhead luggage rack. Lang asked, "Do you mind if I check it?" And Brown responded, "Go ahead." Lang handed the bag to Officer Blackburn to check. The bag contained no contraband. Officer Lang noticed that both respondents were wearing heavy jackets and baggy pants despite the warm weather, and Lang's experienced drug traffickers often use baggy clothing to conceal weapons or narcotics. The officer thus asked Brown if he had any weapons or drugs in his possession, and he asked Brown, "Do you mind if I check your person?" Brown answered sure and cooperated by leaning up in his seat, pulling his cell phone out of his pocket, and opening up his jacket. Lang reached across Drayton and patted down Brown's jacket and pockets, including his waist area, sides, and upper thighs, and both thigh areas. Lang detected hard objects similar to drug packages detected on other occasions. Lang arrested and handcuffed Brown. Officer Hoover escorted Brown from the bus. Lang then asked Drayton, "Do you mind if I check you?" Drayton responded by lifting his hands about 8 inches from his legs. Lang conducted a pat-down of Drayton's thighs and detected hard objects similar to those found on Brown. He arrested Drayton and escorted him from the bus. A further search revealed that respondents had duct-taped plastic bundles of powdered cocaine between several pairs of their boxer shorts. Brown possessed 3 bundles containing 483 grams of cocaine. Drayton possessed 2 bundles containing 295 grams of cocaine. Respondents were charged with conspiring to distribute cocaine and with possessing cocaine with intent to distribute it. They moved to suppress the cocaine, but the motion was denied, although respondents prevail on appeal. It's a lot of facts. So this is That's the procedural context. The facts are above. The court has addressed on a previous occasion the specific question of drug interdiction efforts on buses. In Florida versus Bostic, 2 police officers requested a bus passenger's consent to a search of his luggage. The passenger agreed, and the resulting search revealed cocaine in his suitcase. The Florida Supreme Court suppressed the cocaine. In doing so, it adopted a per se rule that due to the cramped confines on board a bus, the act of questioning would deprive a person of his or her freedom of movement and so constitutes a seizure of the Fourth Amendment. The court reversed Bostic, made it clear that for the most part, per se rules are inappropriate in the Fourth Amendment context. The proper inquiry necessitates a consideration of all the circumstances surrounding the encounter. And the court noted that the traditional rule, which states that a seizure does not occur as long as a reasonable person would feel free to disregard the police and go about his business, it is an accurate measure of the coercive effect of a bus encounter. The passenger may not want to get off the bus. If there is a risk, it will depart before the opportunity to reboard. A bus rider's movement are confined in this sense, but this is a natural result of choosing to take the bus. It says nothing about whether the police conduct was coercive. The proper inquiry is whether a reasonable person would feel free to decline the officer's request or otherwise terminate the encounter. Finally, the court rejected Bostic's argument that he must have been seized because no reasonable person could consent to a search of luggage containing drugs. The reasonable person test, the court explained, is objective and presupposes an innocent person. In light of the limited record, Bostic refrained from deciding whether a seizure occurred. The court, however, identified 2 factors particularly worth noting on remand. First, although it was obvious that an officer was armed, he did not remove the gun from a pouch or use it in a threatening way. Second, the officer advised the passenger that he could refuse consent to the search. So those are material facts in Bostic. Relying upon this latter factor, the 11th Circuit has adopted what is in effect a per se rule that evidence obtained during suspicion-less drug interdiction efforts aboard buses must be suppressed unless the officers have advised passengers of a right not to cooperate and to refuse consent of the search. So there is a per se rule from there, I suppose. And before I go, actually, I will finish up this Boswick discussion. So although the Court of Appeals has disavowed a per se requirement, the lack of an explicit warning to passengers is the only element common to all its cases. Under these cases, it appears that the Court of Appeals would suppress any evidence obtained during suspicionless drug interdiction efforts aboard buses in the absence of a warning that passengers may refuse to cooperate. The Court of Appeals erred in adopting this approach. Applying the Bostic framework to the facts of this particular case, we conclude that the police did not seize respondents when they boarded the bus and began questioning passengers. The officers gave the passengers no reason to believe that they were required to answer the officers' questions. When Officer Lang approached respondents, he did not brandish a weapon or make any intimidating movements. He left the aisle free so that respondents could exit. He spoke to passengers by one in a polite, quiet voice. Nothing he said would suggest a reasonable person that he or she was barred from leaving the bus or otherwise terminating the encounter. There were ample grounds for the district court to conclude that everything that took place between Lang and respondents suggests that it was cooperative and that there was nothing coercive or confrontational about the encounter. There was no application of force, no intimidating. So he was polite. He didn't brandish a weapon. No intimidating movements. Pretty sure he didn't back Nothing coercive, confrontational, no force. There's no application of force, no intimidating movement, no overwhelming show of force, no brandishing of weapons, no blocking of exits, no threat, no command, not even an authoritative tone of voice. It is beyond question that had this encounter occurred on the street, it would be constitutional. The fact that an encounter takes place on a bus does not on its own transform standard police questioning of citizens into an illegal seizure. Indeed, because many fellow passengers are present to witness officers' conduct, a reasonable person may feel even more secure in his or her decision not to cooperate with the police on the bus than in other circumstances. Respondents make much of the fact that Officer Lang displayed his badge in Florida versus Rodriguez. However, the court rejected the claim that the defendant was seized when an officer approached him in an airport, showed him his badge, and asked him to answer some questions. Likewise, in INS versus Delgado in 1984, the court held that INS agents wearing badges and questioning workers in a factory did not constitute seizure. And while either Lang nor his colleagues were in uniform or visibly armed, those factors should have little weight in the analysis. Officers are often required to wear uniforms, and in many cases, this is a cause for assurance, not discomfort. Much of the same can be said for wearing sidearms. That most law enforcement officials are armed is a fact well known to the public. The presence of a holstered firearm thus is unlikely to contribute to the coerciveness of the encounter, absent active brandishing of the weapon. Officer Hoover's position at the front of the bus also does not tip the scale or respondent's favor. Hoover did nothing to intimidate passengers. And he said nothing to suggest that people could not exit, and indeed he left the aisle clear. In Delgado, the court determined there was no seizure, even though several uniformed INS officers were stationed near the exits of the factory. The court noted the presence of agents by the exits posed no reasonable threat of detention of the workers, the mere possibility that they would be questioned if they sought to leave the building should not result in any reasonable apprehension by any of them that they would be seized or detained in any meaningful way. Finally, the fact that Officer Lang's experience only a few passengers have refused to cooperate does not suggest that a reasonable person would feel free to terminate the bus counter. In Lang's experience, it was common for passengers to leave the bus for a cigarette or snack while the officers were questioning passengers. And of more importance, the passengers answered officers' questions and otherwise cooperate, not because of coercion, but because the passengers know that their participation enhances their own safety and the safety of those around them. While most citizens will respond to a police request, the fact that people do so and do so without being told they are free not to respond hardly eliminates the consensual nature of the response. From Delgado Supra. Drayton contends that even if Brown's cooperation with the officers was consensual, Drayton was seized because no reasonable person would feel free to terminate the encounter with the officers after Brown had been arrested. The Court of Appeals did not address this claim, and in any event, the argument fails. The arrest of one person does not mean that everyone around him has been seized by police. If anything, Brown's arrest would have put Drayton on notice of the consequences of continuing the encounter by answering the officer's questions. Even after arresting Brown, Lang addressed Drayton in a polite manner and provided him with no indication that he was required to answer Lang's questions. That's the end of the majority opinion, although there's a ... Justice Souter, Justice Stevens, Justice Ginsburg joined dissenting in 1, 2, 3 pages. Let me get to first looking at the notes, where there are quite a bit. There's California versus Hodari, 1991. Concluding that a person is not free to go about their business does not inevitably constitute a seizure. Sacramento versus Lewis, the County of Sacramento versus Lewis. also concluded that no Fourth Amendment seizure authority represented by flashing lights. No Fourth Amendment seizure would take place where a pursuing police car sought to stop the suspect only by show of authority represented by flashing lights and continuing pursuit. And then in this new case, there's a long one, Shanekloff versus Bustamante, that the consent to search by Brown and Drayton were voluntary. Okay. The authority as applied to them, the consent were voluntary, even though the police did not advise them of their right to refuse. The dissenters believed the consents were tainted by prior illegal seizures and thus did not discuss the illegality. So I don't know how that case got in there. But in any rate, anyone who travels, this is the dissent, by air today submits to searches of the person and luggage as a condition of boarding the aircraft. It is universally accepted that such intrusions are necessary to hedge against risks that nowadays even small children can understand. The commonplace precautions of air travel have not thus far been justified for ground transportation, however, and no such conditions have been placed on passengers getting on trains or buses. There is, therefore, an air of unreality about the court's explanation that bus passengers consent to searches of their luggage to enhance their own safety and safety of those around them, nor are the other factual assessments underlying the court's conclusion in favor of the government more convincing. Before applying the Bostic standard in this case, it may be worth getting some perspective from different sets of facts. A perfect example of police conduct that supports no colorable claim of seizure is the act of an officer who simply goes up to a pedestrian on the street and asks him a question. A pair of officers questioning a pedestrian without more would simply support the same conclusion. Now consider 3 officers, one of whom stands behind the pedestrian, another at his side towards the open sidewalk, with the third addressing questions to the pedestrian a foot or 2 from his face. Finally, consider the same scene in a narrow alley. On such bare-bones facts, one may not be able to say a seizure occurred, but even in the last case, but one can say without qualification that the atmosphere of the encounters differed significantly from the first to the last examples. In the final instance, there is every reason to believe that the pedestrian would have understood to his considerable discomfort that what Justice Stewart described as the threatening presence of several officers. The police not only carry legitimate authority, but also exercise power free from immediate check, and when the attention of several officers is brought to bear on one civilian, the imbalance of immediate power is unmistakable. We all understand this, and as well as we understand the display of power rising to Justice Stewart's threatening level may overbear a normal person's ability to act freely, even in the absence of explicit commands or the formalities of detention. As common as the understanding is, however, there is little sign of it in the court's opinion. My own understanding of the relevant facts and their significance follows. When the bus in question made its scheduled stop in Tallahassee, the passengers were required to disembark while the vehicle was cleaned and defueled. When the passengers returned, they gave their tickets to the driver who kept them and then left himself, after giving 3 police officers permission to board the bus in his absence. Although they were non-uniform, the officers displayed badges and identified themselves as police. One stationed himself in the driver's seat by the door at the front, facing backward to observe the passengers. The other 2 went in the rear, from which they worked their way forward, with one of them speaking to passengers, the other backing them up. They necessarily addressed the passengers at very close range. The aisle was only 15 inches wide, and each seat only 18. The quarters were cramped further by an overhead rack 19 inches above the top of the passengers' heads. The passengers by the window could not have stood up straight, and the face of the nearest officer was only a foot or 18 inches from the face of the nearest passenger being addressed. During the exchanges, the officers looked down, and the passengers had to look up while they were in the face of the police. The officers asking the questions spoke quietly, He prefaced his request for permission to search luggage and do a body pat-down by identifying himself by the name as a police investigator conducting bus interdiction and saying, "We would like for your cooperation. Do you have any luggage on the bus?" Thus, for reasons unexplained, the driver with the tickets entitling the passengers to travel had yielded his custody of the bus and seat of travelers to 3 police officers. Those authority apparently superseded the driver's own. The officers took control of the entire passenger compartment, one stationed at the door, keeping surveillance of all the occupants, the others working forward from the back. With one officer right behind him and the other one forward, the third officer accosted each passenger at quarters extremely close and so cramped that as many as half of the passengers could not have stood to face the speaker. None was asked whether he was willing to converse with the police or take part in the inquiry. Instead, the officer and the police said the police were conducting bus interdiction in the course that they would like cooperation. The reasonable inference was that the interdiction was not a consensual exercise, but one the police would carry out whatever circumstances. I meant to underline this. Whatever the circumstances, and they would prefer cooperation, but would not let the lack of it stand in their way. There was no contrary indication that day, since no passenger had refused the cooperation requested, and there was no reason for any passenger to believe the driver would return and the trip resume until the police were satisfied. The scene was set in an atmosphere of obligatory participation was established by this introduction. Later, a request to search prefaced with "Do you mind?" would naturally have been understood in the terms with which the encounter began. It is very hard to imagine that either Brown or Drayton would have believed that he stood to lose nothing if he refused to cooperate with the police, or that he had any free choice to ignore the police altogether. No reasonable passenger could have believed that, only an uncomprehending one. It is neither here nor there that the interdiction was conducted by 3 officers, not one, as a safety precaution. The fact that there were 3, and when Brown and Drayton were called upon to respond, each one was presumably conscious of an officer in front watching, one at his side questioning him, and the one behind for cover in case he became unruly, perhaps, or cooperation was not forthcoming. The situation is much like the one in the alley, with civilians in close quarters, unable to move effectively, being told their cooperation is expected. While I am not prepared to say that no bus interrogation and search can pass the Bostic test without a warning that passengers are free to say no, the facts here surely required more from the officers than a quiet tone of voice. The police officer who is certain to get his way has no need to shout. It is true, of course, that the police testify that a bus passenger sometimes says no, but that evidence does nothing to cast the facts here in a different light. We have no way of knowing the circumstances in which a passenger elsewhere refused a request. Maybe that has happened only when the police have told passengers that they had a right to refuse, as that officers sometimes advise them, nor is it fairly possible to see the facts of this case differently by recalling INS versus Delgado as precedent. In that case, the majority of this court found no seizure when a factory force was questioned by immigration officers, with an officer posted every door leading from the workplace. Whether that opinion was well reasoned or not, the facts as the case viewed them differed from the case here. Delgado considered an order granting summary judgment in favor of respondents, with the consequence that the court was required to construe the record and all issues of fact favorably to the INS. The court therefore emphasized that even after these surveys were initiated, the employees were about their ordinary business, operating machinery and performing other job assignments. In this case, however, Brown and Drayton were seemingly pinned in by the officers, and the customary course of events was stopped flat. So that makes it distinguishable from INS, which it sounds like what happened. What was the outcome of INS? Consequence that the court was required to construe the record and all the issues of fact favorably to INS. Okay. So that was found in favor of the police, just like this case. In any event, I am less concerned to parse this case. Sorry, no. One more sentence in that paragraph. The bus was going nowhere, and with one officer in the driver's seat, it was reasonable to suppose no passenger would tend to his own business until the officers were ready to let him. Last paragraph. In any event, I am less concerned to parse this case against Delgado than to apply Bostic's totality of circumstance test and to ask whether a passenger would reasonably have felt free to end his encounter with the three officers by saying no and ignoring them altogether. In my view, the answer is clear. The court's contrary conclusion tells me that the majority cannot see what Justice Stewart saw, and I respectfully dissent.